When we talk about live hearings in Title IX cases, we are referring to a process where both parties present their evidence and question witnesses in front of a hearing board. This board isn't a courtroom jury or a group of lawyers, though they are trained to ensure fairness and follow the procedures set by law and policy. Unlike what you might see on TV courtroom dramas, these hearings are not criminal trials, and they don't operate like one. Before we get into the details of conducting live hearings, let's take a look at how Title IX investigations differ from criminal investigations. Title IX investigations and criminal investigations are distinct processes with different purposes and standards. Title IX investigations focus on whether an educational institution's policies related to sex discrimination have been violated. Criminal investigations aim to determine if a crime has been committed under state or federal law. Title IX investigations, the alleged perpetrator is found either responsible or not responsible. In criminal investigations, the alleged perpetrator is found to be either guilty or not guilty. Title IX investigations typically use a preponderance of the evidence standard more likely than not. Criminal investigations require proof beyond a reasonable doubt. Title IX investigations can lead to institutional disciplinary actions like suspension or expulsion. Criminal investigations can result in legal penalties like fines or imprisonment. Title IX and criminal investigations can occur concurrently but are independent of each other. Here at INWAC, we use a preponderance of the evidence standard for Title IX cases. In a Title IX context, this means that if, after reviewing all the evidence, the hearing board determines it's more likely than not that the alleged misconduct occurred, they will find a respondent responsible. It's important to note that preponderance of the evidence does not require absolute certainty or the absence of all doubt. It simply means the evidence tips the scales in favor of one side. Think of it like this: if the scale tips even slightly, by a feather, in favor of one side, that's enough to meet the standard. Over the last few years, technology has become an integral part of how hearings are conducted. As a hearing board member, you'll want to be familiar with the different ways technology might be used. Absent any request from the parties, live hearings may be conducted either with all parties physically present or with participants appearing virtually, with technology enabling them to see and hear each other. At the request of either party, institutions must provide for the live hearing to occur with the parties located in separate rooms, with technology enabling the hearing board and parties to simultaneously see and hear the party or the witness answering questions. Institutions must create an audio or audiovisual recording and transcript of any live hearing and make it available to the parties for inspection and review. Moving on to the hearing process, let's first look at the pre-hearing steps. It is important to note that the hearing board members cannot be the same as the Title IX coordinator or the investigator for the case. The following steps will be taken for the pre-hearing process. First is the selection of hearing board. The hearing will be presided over by a hearing board selected by the college from members of the Trained Conduct Review Board, CRB. The hearing board will consist of 2 to 3 members of the CRB and will be assigned a lead Title IX hearing board chair. The hearing board member names will be provided to each party by the Title IX coordinator at least 5 days prior to hearing. Any objections by the parties must be raised within 2 days. Hearing board members must notify the Title IX coordinator of potential bias or conflict of interest. Once the board has been selected, a notice of hearing is sent to all parties in writing at least 10 days prior to the hearing. The hearing board will convene and identify any witnesses they wish to hear based on the final investigative report. Typically, only witnesses who were identified and interviewed during the investigation may be called at the hearing. Under very limited circumstances, the parties may request additional witnesses, which will be determined based on relevance by the hearing board. The hearing advisors will be identified. Parties may have one advisor for all matters leading up to a hearing and a different advisor for the hearing, but no more than one advisor per party may attend the hearing. If a party does not have an advisor for the hearing, the Title IX coordinator will appoint an advisor for the hearing at no cost to the party to ask cross-examination questions on behalf of the party. The Hearing Board and/or Title IX office may establish additional pre-hearing procedures relating to issues such as scheduling, hearing procedures, structure, advanced determination of the relevance of certain topics, and other procedural matters. The Hearing Board will communicate with the parties prior to the hearing with respect to these issues and establish reasonable, equitable deadlines for the parties' participation input. Permission to postpone a hearing may be granted under special circumstances. Now let's look at the hearing guidelines. Timing. A hearing will be scheduled for a date at least 10 business days after the final investigative report is provided to the parties. Typically, a hearing will be held within 15 business days from the date that the final investigative report was provided. This timeframe may be extended for good cause as provided for in the policy. If granted, the reason for the extension will be shared with the parties in writing. The following hearing guidelines are in place for the hearing. 1. Decorum. The Hearing Board has wide discretion over matters of decorum at the hearing, including the authority to excuse from the hearing process participants who are unwilling to observe rules of decorum. If a party's advisor does not abide by the college's rules of decorum, they will be removed from the hearing. 2. Advisors. While the advisor may be present, the advisor may not speak or otherwise participate in the hearing except for purposes of conducting cross-examination, when directed to do so by the Hearing Board. Other than cross-examination, the advisor may not address the Hearing Board members and must compose themselves in a manner that is not disruptive to the hearing or meetings. 3. Presence and participation at hearing. A reporting party or responding party is not required to participate in person at the hearing in order for the hearing to proceed. All information previously presented by any party may be used for the final outcome and decision-making process, regardless of if parties participate or not. A reporting party or responding party may request alternative testimony options that would not require physical proximity to the other party, including testifying via a remote electronic method. If despite being notified of the date, time, and location of the hearing, the responding party or reporting party is not in attendance, the hearing will proceed. If a party does not appear for the hearing, their advisor may still appear for the purpose of asking cross-examination questions of the other party and witnesses. 4. Hearing format. The Hearing Board has wide discretion to designate the hearing format. Subject to the discretion of the Hearing Board, hearings will typically follow this format. A. Begin with introductory remarks by the Hearing Board. B. The Hearing Board asks relevant initial questions of the parties. During this portion, advisors may talk privately with their advisee. C. After the Hearing Board has completed questions, each party's advisor will be permitted to ask the other party relevant questions and follow up. D. The Hearing Board may ask follow-up questions. E. Questioning of witnesses will follow the same process. Witnesses will only be in the room during the time they are being questioned and will leave after. 5. Questioning at the hearing. The party's advisors, and not the parties themselves, will be permitted to ask the other party and any witnesses relevant questions and follow-up questions. The questioning will be conducted directly, orally, respectfully, and in real time by the advisor. Remember, if a party does not have an advisor present at the hearing, the college will provide, without fee or charge, an advisor of the college's choice to conduct the cross-examination questioning on behalf of that party. 6. Relevance. Only relevant cross-examination and other questions may be asked of a party or witness. Before a party or witness answers a cross-examination or other question, the Hearing Board will first determine whether the question is relevant and explain any decision to exclude a question as not relevant. Advisors are not permitted to object to the Hearing Board's decisions regarding relevance during a hearing. In general, the Hearing Board will not consider statements of personal opinion or statements as to any party's general reputation for any character trait as relevant. 7. Prior sexual history or disposition. Questions about the reporting party's sexual predisposition or prior sexual behavior are not relevant unless a. Questions are intended to elicit evidence that someone other than the responding party committed the alleged conduct, or b. concern specific instances of prior sexual behavior with the responding party and may be relevant to establish consent. Continuing with the hearing process, institutions are required to keep records of the hearing. Hearing record. With the exception of the party's advisors, the hearing is closed to the public. The college shall keep a transcript and audio recording of the hearing. Any other recording is prohibited. No camera, TV, recording device, or other equipment, including cell phones, will be permitted in the hearing room except as arranged by the college. The parties may inspect and review the transcript or audio recording after it is completed. Now that the hearing is complete, what's next? There are still some things to do for the post-hearing process. Determination of responsibility. After the hearing board will make a finding based on the preponderance of the evidence as to whether the responding party violated the policy. In reaching a determination, the hearing board will rely on relevant evidence. The hearing board has the discretion to determine the appropriate weight to assign to all relevant evidence. The notice of outcome will also include suggestions for sanctioning where applicable. Sanctions are issued by the sanctioning authority, but recommendations may be taken into account. If the hearing board determines that the responding party is responsible for violating the policy, the hearing board will refer the matter to the appropriate sanctioning authority, who will determine the appropriate remedies and/or sanctions to be imposed. For student as responding party, the sanctioning authority is the Dean of Students, Director of Community Standards or designee. For employee as responding party, the sanctioning authority is the Executive Director for Human Resources or designee in consultation with the responding party's direct supervisor. For a responding party who is both a student and employee, the sanctioning authority is the Dean of Students or designee if the responding party's primary status is an enrolled student. The sanctioning authority is the Executive Director for Human Resources or designee when the responding party's primary status is an employee who is enrolled as a student as a benefit of their own employment. The final step for the hearing board is the written notice of outcome. After the hearing board will create a written notice of outcome for the Title IX coordinator that will include the following: identification of the allegations potentially constituting sexual harassment, a description of the procedural steps taken from the receipt of the formal complaint through the determination, including any notifications to the parties, interviews with parties and witnesses, site visits, methods used to gather other evidence, and hearings held, findings of fact supporting the determination, conclusions regarding the application of INWAC policy to the facts, a statement of, and rationale for, the result as to each allegation, including a determination regarding responsibility, description of any sanctions recommended on the responding party, and information about the appeal process. Regardless of their participation in the formal resolution process, the Title IX coordinator will provide the reporting party and responding party the written notice of outcome issued by the hearing board simultaneously. Remedial measures and sanctions will not be imposed until any appeal process in the policy is final. Before we wrap up this section, let's circle back to hostile environment. Remember, hostile environment is created by unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the college's education program or activity. Because determining if the conduct was so severe, pervasive, and objectively offensive, analyzing for hostile environment is often the most difficult part for hearing boards. Let's break it down in a way that might be helpful. This information was sent with your handouts. Severe. Severity is based on how serious and harmful the behavior is. Severe conduct is not everyday rudeness, it's extreme and unacceptable. Physical acts, like any instance of anal, oral, or vaginal penetration, are considered severe even if they happen only once. Behavior that is violent, threatening, or humiliating also increases severity. In contrast, things like jokes, online posts, or classroom comments are usually not severe enough on their own to create a hostile environment. Offensiveness alone is not enough. The conduct must be objectively offensive to a reasonable person. This distinction matters. Just because something is rude or hurtful doesn't mean it meets the legal threshold for discipline, though it may still require a response. Pervasive. Pervasiveness looks at how widespread or public the behavior is. Conduct that is well known among others, happens in public, or spreads through social media is more likely to be considered pervasive. The more visible or broadly shared the behavior, the more serious its impact. Examples of pervasive might be a professor regularly making demeaning jokes about women's intelligence or capability, or a student or employee makes suggestive faces, licking lips, or inappropriate gestures in passing multiple times a week, or a student is repeatedly targeted in a group chat with sexist jokes, memes, and harassment, which is seen by many peers. Objectively offensive. To create a hostile environment, conduct must be both subjectively and objectively offensive. As subjective, the person experiencing it finds it unwelcome. Or objective, a reasonable person in the same situation would also find it offensive. Simply being rude or offensive is not enough. The behavior must meet all elements of the hostile environment standard. Denial of access. To qualify as a hostile environment under Title IX, the unwelcome conduct must result in a denial of equal access to education, educational activities, or employment. This means the behavior must go beyond merely upsetting or distracting someone. It must substantially limit their ability to fully participate in or benefit from educational programs, services, or employment offered by the institution. Examples of denial of equal access include, but are not limited to, a student's academic performance declines because of stress, anxiety, or trauma related to the misconduct. A student requests to change class schedules or withdraws from school altogether due to the impact of the conduct. An employee avoids or loses work opportunities because of the hostile environment. Key consideration: the impact does not have to be total withdrawal from work or education. Any significant limitation or disruption in access, performance, or participation can meet this standard. Investigators and hearing board members must look for evidence that the conduct has materially affected the individual's educational experience or ability to function in the school environment. This element is critical because not all offensive conduct, even if unwelcome or inappropriate, will rise to the level of a Title IX violation. There must be a clear connection between the conduct and a meaningful disruption or barrier to access. And with that, we are only one section away from completion. Next up, appeals.